Please be seated.
His work as Chief Justice launched less than 2 years ago, ended just 10 months later. But Jim Zizali's life didn't end with his 70th birthday. He's with us today to talk of life on the court and life after the court on this special edition of Due Process.
Major funding for Due Process provided by the New Jersey State Bar Foundation, committed to educating the public about the law, and by the Fund for New Jersey, supporting informed citizens for an effective democracy. Additional funding provided by Lawyer's Diary and Manual and online legal reference, elaw.com.
New Jersey's Chief Justices tend to be of long tenure. Robert Willent served for 17 years, Deborah Poritz for 10. But the last chief held the state's top judicial seat for just 8 months. I'm Raymond Brown.
And I'm Sandra King, and we're talking today about James Zizali. Now back on the private side. He's our only guest on this edition of Due Process. But first, an introduction to New Jersey's 20th chief.
Bar. It is my great pleasure to present to you Chief Justice James Zizali.
A speech before the state bar. Just 9 months into his tenure as chief.
Please be seated.
Just 1 month before he'd be forced by age to retire.
Before I go any further, I say to all of you hello and goodbye with mixed emotions, not to turn this into a wake. But it is, I do have bittersweet feelings turning 70 in 30 days.
That 70th birthday marked a close to a long career in public service. State Attorney General, Chairman of the State Commission of Investigation, Associate Justice, and finally, New Jersey's 20th chief.
So help me God. So help me God.
Today, he's of counsel at 2 Newark-based law firms. Gibbons, where his focus is on business litigation.
Probably will be a working framework for us to make the decision.
And Zizali Fadula, the firm his father founded in 1925.
Good morning, ladies and gentlemen. The first matter this morning is State v. Jason Williams.
When we heard his report to the bar 10 months ago, his talk was of what had been.
Let me identify some of the accomplishments that began some years ago under the leadership and with the inspiration of my predecessors, particularly Chief Justice Poritz, and some of the programs that have emerged this past year.
And what was still to come.
That's good. That's good. Let's look to the future. Let's not forget the fact that there are generations of attorneys and judges coming down the line. It's our responsibility to educate and inform them concerning their professions, concerning their communities, concerning their opportunities in the law and their responsibilities as lawyers.
And it's our responsibility and pleasure here at Due Process to bring former justices to talk about the law. Chief Justice Zizali, welcome to Due Process. You're our second Chief Justice and one of several former Associate Justices who've come to talk to us, and we're glad you've come to see us this morning.
No, thank you for the opportunity.
It's interesting to use the term tenure or court in connection with the justice, the Poritz Court, the Willents Court. It's obviously unique in your circumstance because your tenure as chief was relatively short. But still, we know that historically people will look back and there'll be articles and discussions about what characterized your tenure as Chief Justice. We'd like to start the conversation by finding out what you think is the principal characteristic, the most important aspect of your tenure.
Well, had not anticipated that question, but I think perhaps it was, I hope, a successful effort to continue the traditions of the court, the reputation, the good work that the court has done over these past 60 years since the modern Supreme Court emerged as a result of the 1947 Constitution. Before that time, if I could just go back in history, before you were born, it was in the 30s, in the 20s, and the 40s, 20s, 30s, 40s, that New Jersey's judiciary had the reputation of being the worst in the country. English historians have commented that if you wanted to look at the common law in its most archaic form, and they're writing in England, they said, don't go to London, go to Trenton. Because it was such an outmoded system that we had in this state in terms of our judiciary. And the brilliant people in 1947, from Arthur Vanderbilt, the first Chief Justice of the modern court, to Bill Brennan, later Justice Brennan, really reformed the system to their great credit. Coming to the present, which I think was the essence of your question, though, I just hope in that little less than a year we did some good things in terms of trying to improve the morale of the judiciary. We all know that the salary situation was abysmal, and Chief Justice started that effort. I continued it. Chief Justice Rabner has brought it to consummation, and we now have a better salary. It's not what it should be, but if we're going to maintain the reputation of being a great judiciary, and that's not me speaking, those are commentators and scholars in courts throughout the country, to keep on attracting good people to the bench, to maintain quality judges on the bench, we have to continue to address the salary situation. We accomplished something there. I also visited the different vicinages. My wife says you sound like a country squire when you use that expression, but we didn't get to all 21 counties. And
Chief Justice Port said it took her 3 years. You did it in 3 months.
Well, I guess that gives new meaning to the word OCD, or phrase OCD, but I had to be obsessive about it, otherwise I couldn't get it done. And
why was that important?
I think to let the judges know, the vast majority of whom are quality, conscientious men and women trying to be fair with their litigants and the attorneys before them, to let them know that Trenton cared, that I cared, to see what their concerns were, their problems, answer their questions, talk about the salary increase. It wasn't just about salary, and I think they appreciated it. And again, Chief Justice Rabner, I think, is continuing that effort.
Chief, when we look at a tenure of less than 1 year, it raises that question of forced retirement at age 70. You've gone on record saying that you're not sure it's so bad. On the other hand, we sit here talking to you, looking at you, and saying, why would anybody force this 70-year-old off the bench? Is 70, as you'll hear someone say at the end of the show, the new 60 or even 50? And is that an outmoded rule?
Or as I said when I was on the bench, is it the new 90? I don't know. Thank you for your thoughts, but I'm of a mind of, Governor Byrne and Governor Kane, you may know this, addressed this question in a debate before the conference of judges that we have each November. Almost 500 judges were assembled, and they talked about mandatory retirement. I'm oversimplifying it perhaps, but essentially Governor Byrne was for mandatory retirement with some qualifications. Governor Kane felt there should not be limits, with perhaps some qualifications there too. There's merit to both positions. It might surprise you because I'd love to still be there. We all would. I like mandatory retirement for two reasons. I think it gives younger men and women an opportunity that I had.
But is the age no longer the right one?
Perhaps not. I think what could be done is either arbitrarily raise it to 75 or do what some states have done and allow the governor to reappoint someone at the age of 70 to a 2-year term, and maybe allow that to happen 3 times, so you'd have to get off at 76. So that's I could be persuaded that that's a sensible approach. But I'm unlimited, on for life. I repeat, I don't think it's I haven't said the other half of it. The first half is that giving younger folks an opportunity. The second half of it is, I don't know that justice is served by having 80-year-old, 85, 90-year-old people on the bench. I know with John Paul Stevens on the U.S. Supreme Court, that's fabulous. He's done exceptionally well. I wish he were there till 100, but he's the exception.
Let me turn to an issue that's maybe the most dramatic issue in the criminal justice system, the death penalty. As you know, back in the time of Furman, when the Supreme Court invalidated the death penalty, Justice Blackmun, who opposed the death penalty, voted to uphold it as a matter of law, citing an excruciating agony of the spirit. We've been lucky here on due process of having a succession of justices who came having voted within the framework of the law on issues about the death penalty, but never overturning it, who then said they, as human beings, didn't believe in the death penalty. What are your personal views on the death penalty as opposed to what you might have done as a justice?
My personal views, and parenthetically, 40 years ago, I argued a major case as a young prosecutor upholding the death penalty. Put that professional obligation aside, that was my job, and I have no regrets about doing that. Over the years, I've always felt, and still do, that in a rare case, the death penalty is a deterrent. And I used to feel, if not strongly, to some degree, that meant it was worth keeping. As the years evolved, I would say the last 10 years, including the service on the court, but even before then, I began to have serious reservations, because if you look at all the factors, the inhumanity of it, the fact that we're not in very good company in terms of the other nations, the 4 or 5 rogue nations that have kept the death penalty, in terms of the whole concept of tolerance and trying to achieve global peace, as we so desperately try to do each century, each decade, that perhaps the abolition of the death penalty in this state and in this nation would be a significant step forward.
Before we leave the death penalty, you've spoken of the fine reputation of the New Jersey court nationally, internationally, but among certain sectors, this court is accused of being, and it's used in a pejorative sense, an activist court. Activist judges making law, and the first thing that they point to is death penalty. This idea that there's been a conspiracy on the court for decades to keep the death penalty from being used, whether it was on the books or not.
Well, let me answer the specific question briefly. As far as the death penalty is concerned, the fact is we never flat out abolished it. What happened is the way it should happen. We defer to the executive and legislative branches, and this past year they took appropriate action. That kind of deference is what I think the other branches are looking for.
But did you hold it at abeyance long enough for that to happen?
Did we hold that in abeyance? I don't think so. I mean, it wasn't just the state courts that were deciding this. It was the federal courts repeatedly have held up on the imposition of the death penalty in what might be considered appropriate cases. But let me shift to the larger issue. Are we an activist court? People who say that we are an activist court, and I say this respectfully, are either individuals who have not read our decisions and they really, with respect, don't know what they're talking about, or alternatively, they do know what they're talking about and they're just demagoguing the issue. We, if you look at our opinions, in every single case, whenever there's a statute involved in the case, which is most of the time, or at least 40-50% of the time, we say flat out, our job here is to discern the legislative intent. What did the legislature intend to do by this language? And if the language is plain, and it usually is, we will defer to what the legislators said. If it's not clear, and that's not because of the fault of the draftsperson, if the language is not clear because of the nature of semantics and language and words, then we again try to determine what did the legislature intend by going into the legislative history, et cetera, et cetera.
Let me play
and by the way, just excuse me for interrupting. Finally, in so many cases, we say to the legislature, if we got this wrong, you tell us, or simply pass a new statute.
Let me play devil's advocate. I'll concede that the definition of activist judges is laden with polemics. But I went to law school in California in the 70s, where California professors pointed to the New Jersey Supreme Court and talked about Mount Laurel, Robinson v. Cahill, as cases in which the court had essentially taken the lead in saying these are social policy questions that have been ignored by by the legislature, and to some extent, we challenged the legislature to meet these issues, and that acted as a model for other state courts around the country. So in that sense, this is a court has dealt with issues that were controversial, that led to much criticism of the courts going too far, and it seemed to me could be seen as judges seeking to extend the appropriate role, as they would see it, of the bench.
Let me step back. I understand where you're coming from. I said the Constitution reformed or altered the landscape jurisprudentially by establishing a new system exactly 60 years ago. In that next decade, with the new court, the first major decision, the activist, progressive, dare I use the word liberal decision, was to say in the Bloomfield Motors case that a person who's injured, and I'm paraphrasing the case, it's been a long time, who is injured as a result of a defective motor vehicle, that person can sue the manufacturer of the motor vehicle. Up until that time, there had to be, to use the arcane phrase, privity of contract. The consumer had to have a contract with the manufacturer. We abolished that requirement. Every state in the country followed suit on that. That, I suppose, was activist. Is there anyone today that would question the wisdom of that decision? And that is simply a paradigm or a good illustration of the type of leadership that we have shown. To me, if we're activists, it means we're simply being fair.
On Mount Laurel.
Fairness is what I think they're really talking about, where we're trying to do the right thing. And if people disagree with that approach, and I don't really think they do, so be it. I'm reminded of what Adlai Stephens had said 55 years ago when I was just a kid. He said the function of government is to be the trustee for the little guy. And I would say, to be politically correct, the little guy and the little gal as well, however you want to put it. But more seriously, it's the function of government in general, and I think the judiciary in particular, to watch out for the little person. And again, I don't think that's activism. I think it's what we're there for. I think it's what the state expects. It's what the nation expects, but within bounds, always subject to the Constitution, these legislative enactments, and our own case law. But there's some leeway, and we don't go crazy, as contrary to what people think. There is some leeway there for being fair, but for being somewhat visionary. And that's why this Supreme Court, and it's not New Jersey judges saying it, the rest of the country has been saying it for 60 years, is, when we enacted, when we enacted our Constitution 60 years ago, the leading judicial magazine journal in the country called, did an article, and the name of the article was The Head of the Class. And the article said that New Jersey, by virtue of its new Constitution, has now gone to the head of the class in terms of quality judiciaries in this country. And I dare say, for 60 years, we've stayed there. We may not be number one. I don't want to get into a quantitative game, but we're clearly right up there. I'm sorry. That's a long-winded answer.
No. I was just going to say that when it comes to something like Robertson v. Cahill or Mount Laurel, there is not unanimity of opinion to this day. And most recently, right here on this set, we saw the charge of activist judges again on the gay marriage question.
Gay marriage question. 7 justices, men and women, Republicans and Democrats, liberals, conservatives, moderates, independents on the court, et cetera, unanimously came to the decision, to the conclusion that there should be equal rights. And by the way, and now, admittedly, there was a dissent. I was part of that dissent, which said that we should also give to partners the title of marriage. If you look at the literature in the last 14, 16 months since the decision came down, I think it came down, I believe, a day before I was sworn in, as a matter of fact. If you look at the literature in the country, the journals, even the more popular press, you will see our 2 opinions, both receiving plaudits because both views were principled, well-reasoned, and an example for the rest of the nation. So whatever happens in terms of the next few years, we'll leave that to the judgment of history.
I know you keep coming back to the Constitution of 47. I actually first think of it as having some anti-discrimination provisions. But secondly, I'm from Hudson County and remember the talk as I grew up of Haig trying to put his relatives and others of the Court of Errors in appeal. Bringing us to an issue that I know you've talked about, been to a conference where I think Sandy followed you with a camera, about elected judges, which exist throughout the country, versus appointed judges. You have strong feelings on that. What, do you think that's connected to the idea of...
But this interview has been in an education. I did not realize that Sandy was a paparazzi.
We haven't gotten to the good stuff yet.
I be careful with that camera. Okay. Georgetown University Law School, my alma mater, did a program on the very issue of active versus elected judges last October, as I said, and I was asked to speak, not knowing that in the front row when I spoke there would be Justices Breyer, O'Connor, and Souter. And my argument, and it was soundly debated, because there were people on the other side, judges from other states, Texas and so forth, is that if you want an independent bench, you really have to have appointed judges. Not a perfect system, and certainly not a perfect system in New Jersey, but by and large, the integrity and the independence of judges, I think, depends on their being appointed rather than elected. How you can possibly, in a consistent manner, judge fairly when you have advocates, attorneys in front of you, when you have parties that they represent, whom you know, who have contributed to your campaign, who have been active campaigning for you or against you. It's beyond belief. And I think my view is almost empirically established in the sense that studies have demonstrated, confidential studies in one southern state, for example, how 60% of the judges acknowledged that contributions to their campaigns affected their judgment when making decisions. That was a confidential poll, predictably.
So is that how we moved from what you described as being at the back of the class to the front of the class, moving into what you see as a more equitable system?
There's absolutely no question that we would not have the reputation we have. We would not do the good work we have done, but for the fact that we are appointed. And to the credit of all of these governors that we've had, Democrat and Republican, they generally have taken that appointment process so seriously. What's fascinating, and very few, if any, states have this, is that in our system, the number of judges is apportioned equally between Democrats and Republicans, maybe one or two off out of 460.
There could be an argument that that's a bad system, not a good one.
I haven't heard that argument, but take a crack at it.
Well, if in fact you are conscious of how many Dems do we have and how many Republicans do we need, are you going for the best person?
Well, because I think there's so many good people within both parties, I think you'll end up with among the best people. The difficulty is that well, the good news about the split is that it's not required by any constitution or statute. It's been a custom, and yet the governors have honored that. Are we getting the best people that way? I think so. But most important, we have a public, I would hope, that now has confidence in the system. If they're aware of these things, and that's a separate issue, Chief, and it's troubling that perhaps the public does not know what it ought to know.
With less than a minute left, let me ask you an unfair question. Any opinion in your entire tenure on the court that you regret or would change?
No. That's not, and I'm not a cocky guy. No. How
about if we go back to Attorney General? I'm trying to reach here.
But that was shortly after the Civil War.
Okay, and with 30 seconds left, let me ask you.
There are a couple of obviously there are things I would have done differently. Nothing major. I'm basically comfortable. As I said before, maybe I could have dissented a few times more often than I did, but that's a separate
15 seconds left now. We've talked about where the court's been. Where's it going? What's the next big decision?
I don't know what the next big decision is in terms of the litigants out there and the attorneys. Every decision is the next big decision. And in every case, this court, and I know it's true of the present court as well, will try to do justice.
So when the next big decision comes, you've got to come back and talk to us about it, because we've got to go. Our thanks to Chief Justice James Cizali. That's it, unfortunately, for this edition of Due Process, but you'll really want to join us next week for more in-depth looks at the law and social justice. For Sandy and myself and all the rest of us, I'm Raymond Brown. Thanks for watching.
I think, 70 is certainly too young, because 70 is probably the new 60 or 50 even. So I think that's very much too young.
I think that a judge is probably hitting their stride when they're 65, 70, and that it could make a lot of sense for the Supreme Court for them to be able to serve longer.
It's true that somebody over 70 could be perfectly competent and great at their job, and it'd be a shame to make them retire.
Maybe it should be a little younger. Maybe it should be a little younger, because it seems like 70, everyone is out of touch with what's happening.
By the age of 70, there are concerns that, that come up.
People advance in wisdom and in stature with age.
I think one of the greatest Supreme Court justices we ever had was from New Jersey, was Justice Brennan, and he retired when he was way over the age of 70. So I think that would be a good indication that they should not have to retire when they're 70.
Major funding for Due Process provided by the New Jersey State Bar Foundation, committed to educating the public about the law, and by the Fund for New Jersey, supporting informed citizens for an effective democracy. Additional funding provided by Lawyer's Diary and Manual and online legal reference, elaw.com.